Okay, so we can get started here, and welcome back to our last segment of our AI program. And this is going to be a legal ethics panel about artificial intelligence, using artificial intelligence. And if we run out of material, we'll just talk about general ethics to make sure everybody gets a full hour. It's 12:38. We will go a full hour to make sure everybody gets one credit in every state, whether you use a 50 minutes or 60-minute state. So let me introduce the speakers here. Starting with the audience's left, we have Gary LaBelle, and Gary is a senior patent attorney with Ricketts. Gary is also former general patent counsel at Nestle's. He's been a good friend to us. He's spoken at many of these. And when we first moved in here, we realized that Gary's a neighbor. Gary doesn't live too far away. So it's great to see Gary. Thank you for being here. We appreciate you being here to give us the in-house perspective, which I think is very critical, very important. And a lot of the places where people can really stub their toe in this particular area right now, if you don't take into account the in-house perspective. And we have Will Covey. Will is the top ethics officer at the USPTO. He's deputy general counsel, and he's director of the Office of Enrollment and Discipline. So let me ask you generally, we can start with, and I should also say, this being a CLE hour, we have materials on the panel page. You can download the articles that are there. We also have a recent Federal Register notice published by the Patent Office, and we have, I think, some slides that the PTO has put together. It's always an iterative process, so they're constantly putting together new slides. These are not like as of yesterday, but these are probably as of a few months ago, the last time the PTO updated their slides publicly. So, Will, let's start with you. And I don't want to pigeonhole what you want to talk about, because I love having you join us. So, because I think as practitioners, it's important for us to understand what the Office of Enrollment and Discipline is doing, what you're seeing, what problems people are getting into, because it's educational for us to know. The topic is AI and anything related to AI and the rules and concerns. But feel free to tell us what else is going on or anything. Where do you want to start the conversation and prime the well?
That's a great kickoff to a discussion of AI. And I think courses like this or practitioners trying to kind of understand the landscape of what's going on, keeping up to date is super important, because things are changing very rapidly. And it's something that I call them reminders, basically, because I think a lot of the rules that are already existing, specifically for your professional responsibility obligations before the office, you just need to go back to them and take a look at them. And I know we're going to, in other talks we've had, Gene, we've kind of touched on those. So that's one thing I would say, is it's not something it is a brand new technology, but it's basically the same rules of keeping your clients' confidences, making sure you're competent. I mean, I'm sure many of you have seen the news stories of briefs citing cases that just don't exist. Well, and they attribute that to AI. We've had cases before where lawyers, and not related to AI, where the attorney has made false representations. They've totally misrepresented things. And Gene, you and I chatted about the Hicks case at the Federal Circuit about 8 years ago. So it's not AI related, but it's the same principles, right? You need to make sure that what you tell in the court or a tribunal, and remember, examiners are considered a tribunal under the rules. So whatever you tell an examiner, that needs to be, you need to do something. And OED's position in that, since I've been leading that office, is we're not going to prescribe you how much you need to do. We're just going to say you need to do something. You can't do zero. You cannot just turn something in and rely on paralegal, and AI is another tool, basically. You cannot just rely on that and turn something in without at least checking it. Some foreign reference. That's another example I've heard over the years. How much of the foreign reference do I need to read? And it's like, well, remember in law school you read
enough.
And that's the answer, right? If you remember in law school, Did some of us, and I'm not going to ask you to raise your hand, did you, in some of the cases, I'm sure it's a small minority, did you just read the head notes, right, in the cases? And was that good enough? You kind of get a sense, and we rely on the practitioners to kind of make those kind of judgments as to what do I need to read, what's important, and my own experience kind of bringing that to the table too. So that's what I would say. Don't be afraid of AI, but I think by understanding what's going on, and there's two pieces here, the inventorship piece that I think you talked about already in one of your earlier sessions, we can chat a little bit about today, and then the obligations for the practitioner, and how do those two marry up, and how do you make sure that you, as practitioners before the office, one, protect your valuable license to continue practicing before the office. We have actually one case that we think is an AI. We're going to call it an AI case. I'm not going to say where it came from in the office, but that may be true, it might not be true. It might be an AI case. It could just be sloppy work by the lawyer who filed the papers before the office. It could be worse. It could be an intent to basically deceive the office, right, by citing some legal source that just doesn't exist and creating citations or quotes from that support a particular position. But there's enough in the news, and I think it's great that the bar is attuned to this issue. There's enough cases already out there. The first one I saw was out of Texas. And I know there's been one, I think Michael Cohen recently, as if he's not in the news enough. Then
or in trouble enough.
Or in trouble, yeah. Then his lawyers, if you haven't seen that one, lawyers citing cases that just don't exist, right, and for different propositions. Fortunately, right now, other than this one case, if you're in the patent world is pretty quiet right now as far as OED is going. Mainly, most of the problems are coming from overseas in the trademark filings. But bringing it back to AI, I try to push or put a look at things when it comes to us through the lens of nobody's perfect, right? There are going to be mistakes made by an attorney or by an agent. As long as they've taken reasonable steps and attempted to comply with the rules, I think that's basically all that we can ask for. And by the way, if you don't know, the office does run I'm going to call it a helpline or an assist line, basically. You can call in. Does anybody not know that? Do many of you know that or not? You can call the PTO, ask questions about the rules. They're complicated, no question about it, because our rules, then you got state rules that you have to comply with, and sometimes they don't always marry up, exactly. So if you want help and guidance in that, call the office. And
not you, your friend. You're calling for a friend.
That's right, and you don't have to say that too. So, and I tell
you
that.
don't even have to.
And I know you're recording this, Gene.
No, but you don't have to give your name, right?
You don't have to give your name. Yeah. We don't really care. We don't look at the phone number and then try to figure out. Go in and say, oh, what's Gene's registration number? We better pull all his cases. We don't do that, and we make that public promise. It's really intended to help the bar out. As far as understanding and that's what we want. We can only ask you to try to comply with them, really. A good faith effort, because they're complicated, and if you make a mistake, you got to own up to it really fast, I think, as soon as you find out. That's also key. We've had many cases where, let's say in the AI world, and I know we're talking about that today, you find out later, you didn't know at one point, but then you find out something later. Usually hiding things, right? We all know that. It usually never gets better as you kind of try to avoid, coming to grips with something. We've had cases, not in the AI world, but I would say that this should also apply, because it's really no different, where mistakes were made. The attorneys contacted us and told us, hey, I made a mistake in this case, and this is what I'm doing to fix it. That's perfect. That's fantastic. I love to hear those types of stories.
Yeah, and I always like to say, I know I've asked you this every time we've ever talked, and I just like to give you an opportunity to say it out loud so everybody can hear it. We've known each other for years, and I trust you. I think you're as honest as the day is long, and you really just want things to work well, and you're not looking to jam people up. And in my experience in working with OED, occasionally representing an attorney who has an inquiry or whatever, my experience with OED is your entire staff. They're not looking to jam somebody up. They're not looking to immediately rush to judgment. You just want people to take responsibility and do better. And that's your philosophy of running the office, right?
That's 100% right. And I don't want you to be afraid to call us and ask us to use this help too. like I said, we promise, public promise, we don't go in, we try to figure out what's going on with you. And I think it's good for the bar, and I can prove it with statistics. The bar's size compared to, I look at states, and I'm not going to name any states because I've gotten calls, they get mad when I call them out, and I compare the discipline, our disciplinary cases to what's, relative size. For example, Massachusetts.
Yeah. We won't name any states, but for example, Michigan too, right?
Yeah, that's another one, right?
The M states.
The two M states.
They're big bars.
Not Montana, right?
No. But they were big bars.
Yeah.
And much larger than ours, and our membership has many fewer problems than those much larger bars.
100% true.
Yeah. So just be honest out there, and if you make a mistake, rectify it. Okay, so there's a lot that you said that we want to come back to and dive into.
And I will say the AI world, like I said, there's a lot, and hopefully I think we'll get into
we'll get into.
You need to keep up to date, and there's a lot of things that
rules.
we're going to try to make sure that you're aware of, that you can then make sure you've got the latest, because there's a competency requirement, obviously, that you need to have before the office too.
So before we dive too deep in there, Gary, let's get your preliminary thoughts as the client, as the role of the client, and you're an attorney. You have the ethical ball and chain, just like all the rest of us do. But so you can take this anywhere you want for your preliminary comments. But I do want to ask you questions about, from the client's perspective, what do you want us to be doing, and what do you expect? Because that is one of the rules that a lot of people are getting jammed up right now, is the communication issue. But go ahead, Gary.
Well, being in-house and also doing a lot of due diligence, I think the in-house patent attorneys aren't doing a good investigation with their own people. And about a year ago, when all of this was coming out, we started to ask, are you using AI? And we had to explain the difference between generative and non-generative, all that, so that they had an understanding. But quite often we found out they hadn't used it yet, and then we come back with a draft and a whole bunch of questions. And then I had the bright idea, I'm going to ask again. All of a sudden, there was a lot of AI that was used. Oh yeah, I got that in ChatGPT, I got that here. In doing due diligences, I've been in companies and I've looked at different patents, and you start talking to the inventors, you're finding out that there's a lot of it that they got the idea, they got the genesis, off of ChatGPT or some other generative AI, and nobody ever asked the questions.
That's really problematic, and I also know, and maybe you can comment on this as well, a friend of mine, and I know he said it at programs, but I'll anonymize it. But so at a major filer, let's say, like a top 20 worldwide filer, so, major company. And he's the top IP guy there, and he's told me if I ever found out that one of the firms we use was using AI and didn't tell me, it would be the last piece of work they ever got from me. I mean, do you share that concern? I mean, the need to make sure that the firms understand that this is important, keep you in the loop, and respect we talked about AI governance the other day, and respect your governance and your rules and process.
Yeah, absolutely. I mean, we need to know what our firms are using and how they're using it. Taking a draft application and making sure that the claims are supported in the spec using AI is great. It can solve problems later. But how else are they using it, and is it capitated or is it going into some database to train? Is another idea.
And where's the server?
Yeah,
too. I mean, because for that, and years ago, the PTO issued a Federal Register notice. We just laughed about this during the last panel. It's like when the PTO comes out and says, "Look, nothing's changed, just a reminder,"
right.
which you guys do every once in a while. About 10, 12 years ago, the reminder was, remember the export rules, just a reminder. That's critically important in the AI world, where this data is on the server. Not that it should matter, but it matters for the Bureau of Export.
100%. And Gary just touched on a few things too, right? The the confidentiality, right? You start dumping this into a chat, you don't know where it's going, who's using it, if it's some non-public information. That's just huge red flags. But one thing I know it seems like we're saying all the negatives, but from the things I've seen and read already, AI obviously offers huge benefits to the economy, to the practice. So we shouldn't be afraid of it. We should make sure we
Respect it.
And kind of make sure we understand what it can and what it can or should not do.
And respect your clients too, because one of the rules that people I've already gotten jammed up on. Not that there's been a lot of people in the AI context that have been jammed up, and I'm not jammed up at the OED, but in states where these issues have started percolating. First, is the rule that says communication and informed consent. And our rule on that, I had it open. I think it's 11.104, which talks about communication, and that's a big issue. You have 11.104 of the 37 CFR talks about communication, and the communication needs to be enough to inform the client and get consent to do what you want to do. And that's a big issue in the AI space. Will, any thoughts there?
And it seems like to me it seems people are not 100% certain what the AI may be, and it could be different for different clients too, right? Depending on the level of sophistication too. So I wouldn't be surprised if, like what you were saying, there's lots of like boundaries or walls being put out by clients right now until they've kind of figured this out, until we see where this, because it is at the very basic stages right now, it seems to me.
Yeah, and I said this the other day, and I think you were here, Gary, when I said it. When you don't want to, I don't think you want to engage with what I refer to as the pretenders. People who started doing AI this morning. You want to do people who have thoughtfully in their own company. They have governance documents. They can tell you where the data is served. They can tell you how it's being used. They can answer all your questions, and they don't come back with, well, why does that matter? And then also folks that we've all got these emails. It takes you 45 minutes to draft a patent application. With our AI, it can take you 5 minutes. It's like, okay, well, clearly that company doesn't know what we do. They don't get what we do. I think you need to be working with real reputable companies that have real transparency. Is that what you want to see from your outside counsel?
Definitely, but one of my biggest concerns is when my inventors use ChatGPT, my duty to disclose it. How do I disclose? What do I disclose? It could be very material to patentability.
Mm-hmm. Do you find that your outside counsel are asking those questions, or is that what you were referring to earlier when you were talking about you followed up and you were asking, was it that they weren't asking where the...
It was a company, their internal didn't. Mm-hmm. To be honest, I don't know. I don't think I've had an inquiry.
So that is concerning too, in some respects. I mean, that maybe, and I know this is all new and it's all exciting, and there's a first to file. You got to get things on file quickly, but I think we got to take a step back and make sure that the inventors aren't using this stuff, and if they have, then that should provoke a whole host of other questions.
But I send my outside counsel, I've been doing this for about 6 months, a statement about AI. It was used, it wasn't used.
Okay, so you were providing...
So is that why I don't see the inquiries, or is it not sensitive to our outside counsels?
Yeah, and it's probably hard to know, but one of the things, and there's so much for us to talk about, we already laid out that I want to get to, but one of the things that just came up in the last panel, and Will, we were talking about, I mentioned this to you, is that this idea of inventorship. Obviously in AI, every country, except I think Australia has decided differently, but they have more of a registration system, has decided that AI cannot be an inventor. So the problem becomes you file these applications. We don't have to say who's the inventor on each individual claim. It's like, here's 4 inventors. They contributed conception to at least one claim. Well, now years later, if you wind up taking out the only contribution that the individual, the real person, added, now you have a patent that has only an AI that conceived, and that's problematic. And what are the best practices for prosecutors to keep track of that? And then the other question, and I think I know the answer, but I'll give you the opportunity to say it, is OED thinking about that? Are you concerned about that? Is OED going to get involved in, this as being an ethical issue, or is it wait and see and try and help people do the responsible thing in the meantime?
Yeah, so we don't have anything on our plate right now that directly goes to that. I'm guessing we will at some point, because I think already these court cases you've seen where they cite citations that just don't exist. It's like you're scratching your head, like, if they're doing that right, what else is going on out there? I think it's, as I start off by saying too, I think it's important for you as practitioners to understand what are the rules and how is the USPTO looking at during prosecution? What role can AI play? And the answer is not that it can't play 0 role. That's not what the PTO is coming back and saying. So they got 3 factors. I don't know if you talked about this.
No, not yet.
Or do you want to jump into that? Go ahead. So the 3 factors for inventorship that came out of a case in the late 90s. And I'm not sure I'm saying this right. Is it PANU, right? Is there PANNU are the factors.
Okay.
So there's a case that talked about 3 factors, and the factors are each named inventor must contribute a significant manner to the invention, and then there's a second factor, the quality of that contribution, and then the third is a mere explanation of the state of the art. The inventor must do more than merely explain to the real inventor the concepts that are involved. So that was from the 90s, so way before AI. The PTO has taken that and said that's a good basis to start with. Then they've added on to those 3 factors, they've added on what they call guiding principles. And this is where I think, again, practitioners need to kind of keep up what's the latest state of how, if my inventor does use AI, where is there going to be a problem possibly down the line? And to answer I think your initial question was, I suggest that practitioners who are prosecutors keep some type of contemporaneous notes. The litigators hate me when I say that, right? Right, because it's a smoking gun. I get it, but that's up to you to decide, because the way it could play out is we could be asking questions about your license 5 years after the fact, right? And why you did, or specifically if you didn't do something or disclose something, you may not be able to remember that down the line. I'm not telling you need to take super detailed notes, but I think it's always good to have something to jog your memory. Like I said, full disclosure, the patent litigators absolutely hate that when I say that, but okay, that's their point. I get it. They're looking at it from their end. I'm looking at it from your license perspective, because I've seen instances where we are asking questions years after the fact. And if I asked you, what did you have for lunch 2 weeks ago, you might not be able to tell me. But now I'm asking you.
Let's talk about that. What is the statute of limitations? And people need to know this.
Right. So the statute of limitations is, and this was changed in the American Invents Act a little over 10 years ago, is 1 year from the date the USPTO, from the date that the Office of Enrollment and Discipline is told about a potential violation of the professional responsibility rules.
But it can't be more than 10 years ago,
But
right?
it can't be more than 10 years.
So the statute is 10 years.
It could go back 10 years. So you need to keep that in mind. That's why I suggest some type of note. It could just be something to jog your memory. It doesn't have to be detailed. I'm not asking for a 10-page memo on why you cited or didn't cite a reference, in an application. But I think something would be helpful to you. So, and I've seen instances where that does come up, and they say, "Oh, I have I have something where I could help, kind of as evidence, basically." Versus, gee, I don't know, I can't remember. They're being honest with us, and it doesn't surprise us. But great point that the statute of limitations for you to think about is 10 years. Could be up to 10 years. That's
And
a long
that's a
time.
long time.
I mean, so 10 years ago, right? 2014, who was the president? No.
Yeah, right.
I mean, it's a long time ago, right?
Yeah.
Or 9 years ago to be asked things about that.
No, it is. Now, Gary, let me ask you on that front, what do you expect from your outside counsel? I mean, do you have any expectations of them retaining the files in some level, going through and doing, not purging for, after you've been noticed that there's a litigation, but, the document retention plan? Do you have anything that you expect your outside counsel to do and to keep? And so, like, if questions do arise, that they can at least say, oh, hey, all I've got in my file is just the issued patent. We destroyed everything else. I mean, what do you want?
We expect them to have reasonable retention, but I think there's also an onus on the inside counsel. I do an inventorship analysis. It's in my notes. And previous company had to rely on that document that I had, why I made the decisions I did.
That's great.
And I think the inside counsel needs to not just be, a pass-through. They need to function as well.
That's a great. Now, I read the OED reading room. Obviously, the stuff that's private reprimand stuff doesn't get there.
Right.
I don't know that I've ever seen you go after anybody that's in-house. I mean, and so these problems, not that they can't have done something.
We have.
Okay.
And let me just mention, too, the statute of limitations is one piece. And you may be thinking in the back of your mind, yeah, well, how does that apply to me? Or, how's this going to come up for me? Why is this relevant to me? Well, guess where we get information from? We get it from the examiners, we get it from the boards, but also a prime source of information is opposing counsel.
Right. And judges,
Judges,
too.
as you saw, Delaware recently issued a decision up there for some interesting
What was
conduct.
going back to the Hicks case, and maybe we should talk a little bit about you so everybody understands, but that's where that came from, right? The Federal Circuit in a decision said, hey, we are going to sanction you because you violated our rules, and any idea of what it should be candored to this
Just
tribunal.
complete misstatements to the Federal Circuit. And we get it, there's some argument, you're trying to represent your client, but there are lines, obviously. And if there's any court for a patent attorney to be publicly basically slapped on the reprimanded, basically, it's the Federal Circuit. Because why? Well, the PTO is there all the time. That's
Right.
our home court.
We're
That's
all
where we
reading
go
those
there.
cases.
Right. We're reading, and we have lawyers going up there for cases all the time. So
let me again, I know the answer here, but just so everybody else hears this, well, you're not scouring the cases, district court cases and others, looking for people. Oh, we can bring a case based on that, or we can bring a case on that. These are people coming to you and saying, hey,
Right.
FYI, this is something that I think I need to let you know
Right.
about.
We don't review PACER. We don't go looking for stuff. All of our cases, when we have several hundred per year, like I said, they're coming from the examining course or they're coming from the boards. But a good chunk of those referrals to us, opposing counsel or former associates or partners of the firm who didn't like something that was going on, and they're contacting us, say, hey, by the way, you might want to check this, and this out. And sometimes they get submitted to us anonymously. We try to protect identities so that we get a good flow of information. But yeah, we're getting lots of information from the outside courts also, and then the states are also, which is good. The states sending us things that, especially in the patent area, because that is, there's no question, ifs, ands, or buts, that the patent. Trademarks a little bit more because they're not registered by us, right? They just need to be a member of a state bar. But we're getting information flow, good information flow from the states. And we're also now, so one of the other things we're also starting to do is starting international discussions with other international patent offices and trademark offices so that we can, because some of the bad behavior is coming from overseas. We want to start using the embassies. I don't know if you know this, but the PTO has PTO employees, attachés in some of the key embassies throughout the world to advise the State Department folks about patent and trademark issues, countries like India, China, over in Europe, So these key markets and key places where we're seeing things, we have experts over there who are kind of leading that discussion, which is great because we're also starting a discussion of sharing information, so that because it really knows no borders, really, right? It doesn't stop at the U.S. border.
And you've made some of those trips and diplomatic missions over to those places too, right? I mean,
So I'm going to China this summer and start talking to the Chinese CNIPA about some of the issues we've seen. And it's good. They want to talk about them too, which is fantastic.
Right. So, and just so that we keep all the state regulators happy and not just you ethically, the duty of candor for the tribunal, toward the tribunal, that's Rule 11.303 in our PTO rules, 37 CFR 11.303. And that one is, and as well as the communication rule, very similar to the ABA model rules that apply pretty much everywhere. And that was one of the things about 10, 12 years ago you did, is you largely adopted, not completely, but largely adopted the ABA model rules.
99%.
Right. Not the stuff on crime, because it's not relevant to us and that sort of thing. But so candor towards the tribunal, that is the basis of this latest Federal Register notice. And what I want to say, if you've been paying attention to what's been going on, Director Vidal issued a memo the first week of February talking about all these cases where people have been, all of them, all 2 or 3, where people have been filing briefs with fictitious made up stuff found using generative AI, and said, this is how we're going to treat it. More to follow. In the last paragraph of that memo, she wrote, within the next several months, we'll have a Federal Register notice come out explaining more of our position on this. The next week, a Federal Register notice came out. There was 1 or 2 columns of that notice that dealt with duty of candor, but that was not what she was referring to in the memo. There will be a longer version, and you're working on that now as you work on these things iteratively for a while before they come out. But what can you tell us about whether it's the memo that has been made public, or that the Federal Register notice that had a couple lines, columns dealing with our duties, because it was related to the PTAB and the TTAB, right?
Well, and the General Counsel's office also is listed, right? Because that's where OED resides. So I think, and here it is right here. I have it right here. I brought it with me. And this is kind of what I would suggest to the practitioners, is that to keep yourself up to date what's going on. This is not a long read. It's I think it's 5 pages long. It's four and a half.
Yeah.
The last page is really short.
Yeah.
And then she's got a huge signature block on
Right,
the front.
right.
So
It's a quick
really
read.
It's a quick read. There should be. I can take my word for it, but also read it. Also, if you get time to. There is nothing new in this document. It's I call them reminders. It's existing principles. There's nothing specific about AI at this point that we need to say, oh, we need to rewrite the rules, or we need to add this, or we need to think about this. From what the practitioners should be, you should be already doing. You just need to think of it through the lens of now AI, because AI is different. Like I said, it has a lot of potential and possibilities for the country and for inventors, but it needs to be done smartly. You need to step back and make sure that you're not one of these people that we're talking about, like, oh, you submitted this and it didn't even exist because you didn't read it. So, which to me is shocking to see cases like this, people submitting, any lawyer submitting something that they're not reading the case, or hopefully everybody's shaking their head. It's like, you just can't make this stuff up, right? And I mean,
it's hard to believe that anybody had done that. Now, what I had, I'll ask you publicly, and feel free that you can say I can't answer, or more to follow,
Either
pay
admit or
attention,
deny,
watch, whatever. But so far, what Director Vidal said, and then the one Federal Register notice that we do have, has focused on PTAB, TTAB, filing briefs. I don't think I've seen anything yet regarding prosecutors who are filing applications or prosecuting.
that's all coming, right? So,
And that was the next question. And that's the stuff that's in process.
right, and that.
Is there anything you can tell us?
Well, one thing I would point everyone to, and it's yesterday the PTO had a workshop. It's being recorded. It's going to be posted on the webpage. There are slides, and I brought them here, and there are. Let's see how many. They're very quick read. The slides, there's 37 slides. Gives you a great overview, and you got to remember, that's for inventors, But it also applies to you because you're going to be advising those inventors to understand what are the parameters where AI is involved. So these are going to be posted on these two documents, I think, are two key documents I would look at this point. But you need to remember, hey, this is going to change. You got to keep up on this. You got to keep abreast of the changes because it is going to change. And one thing I think with these Federal Register notices that is a key point is that the PTO is trying to work with the public and you as practitioners and vendors to understand what are the concerns. Are we getting it right? I can tell you, having sat internal, I don't know what I think people probably think, well, when we get these comments, we just like throw them in the trash, right? We just say, we're going to do whatever we're going to do. That doesn't happen. There is a massive amount of debate over the comments that come in because many of the comments, and we make changes to the rules based on what we hear from the public too. So if you see these things, if you have time, we always take input from the public, and we have listening. We do listening sessions also too. I know these things are time consuming, but this is really important that we get it right at this point, at least get it on the right track. Not that we can't fix it if we find out there's a problem down the line, but a lot of public engagement, a lot of major stakeholders are weighing in on these things.
I swallowed wrong right at the wrong time. Gary, any thoughts about what we've been talking about here now and how you'd like to see your council, whether there be people who work for you internally or externally, do and take into account?
I think they have more people to be able to look at the rules and the nuances that are happening and give better guidance in the short term. But again, I don't think that obfuscates my responsibilities and my responsibilities to my company.
Yeah.
And one of the guidances that I'm looking for to see what's going to happen is how do we submit that stuff from ChatGPT? Because I think going down the line, that's going to be the biggest issue in a litigation.
Like on an IDS, right, or something like that? Is that what you think?
Right, yeah. I foresee that as an issue, maybe not with
That's an interesting question, yeah.
But, if I'm in a due diligence talking to somebody and they've used it, that's surely going to come out in a litigation.
Right.
If we have to defend it, and is that patent valid?
Yeah. When you say surely going to come out of litigation, I was just sharing it with somebody. I saw a meme the other day, and it said, you can dance like nobody's watching, but you have to send emails like they're going to be read out loud in court, because everything comes out during litigation. Right? And the more money that's at stake during the litigation, the more stuff that you think you can't imagine how it's going to come out, it will come out.
Can I mention one thing too?
Sure.
So one thing that Gary just said too about, what are you going to disclose to is there any disclosure requirement to the PTO as far as did you use AI or what level? Yesterday, and I know this was the answer that was coming out, was because there's been some discussion. At this point, you're not going to have to fill out a form or anything like that. There's no certification or anything at this point. The reminder is, and we touched on it a couple minutes ago, is the Rule 56, the duty of disclosure to the office and what you are you compliant with? Rule 56 is not new. Rule 56 seems like it comes in the news every few years. The other thing the office mentioned, I think it's important to touch on, is, and this would be in a rare and exception, I think, situation, is Rule 105. Does anybody know what Rule 105 is? Except for you. Yes, exactly. Very good. A+ there. Right? Rarely used by examiners. Different scenarios and different things the office have had. That's actually been talked about over the years. There's different reasons why or why not. Why we kind of haven't moved forward with that. But the discussion yesterday with regards to AI is maybe in those, if the examiner in rare and unusual circumstances, remember, dust off. It's already on the books. It's been on the books for a while. 105, where the examiner could then ask, ask questions if there's some concern as to what's been submitted to the office. So maybe kind of familiarizing yourself with that in case it comes up.
So that's interesting, because with 105 and request for information, you can say, oh, this is it's too much. Just same with interrogatories. It's not practical for me to come up with this information, and I can't provide it. But that actually has to be true. And even more so than in litigation, because we have an ex parte.
During the ethics hour, he says that, right?
Right. It's got to be true, but it's even more true during litigation than litigation, right? Because we have an ex parte rule, But have you given any thought? And if it just came up yesterday, the answer probably is no. Or just over the last few weeks when you're putting together these slides, have you given any thought as to what your position will be on what is something that you think is reasonable for an examiner to ask for, and that if an attorney said, "Oh, I can't come up with that. That's too burdensome," or too, because then it gets back to the record keeping aspect of it all.
Yeah, at this point, I don't think I could. I mean, I just heard that, and I've known about Rule 105 because it's come up in other contexts. I thought it was an excellent suggestion. I just wonder whether are the examiners actually going to do that, right? Because they did say, hey, that's going to be a rare and exceptional situation. But don't forget, if when things end up in litigation, if you're prosecuting patents, how does your license now all of a sudden possibly come into question? Opposing counsel, something that comes out in court where there's evidence that gets pulled out in discovery, they are very quick to tell us, and they'll always start off the letter like, hey, I'm just a good citizen. I'm just trying to help the system out. I just want to make sure you're aware that so and so here's the evidence, and they'll write these beautiful letters laying everything out, all the evidence tabbed and indexed and everything. It's like, wow, this is awesome. They just put the whole case together for us too, but they're just trying to be the helpful practitioner to the system.
Well, and it's not
that happens. Believe me, it happens.
Well, I know for sure that happens, and it's not only because they're just trying to be helpful, but also there's a rule that says that if you see something, you have to say something.
That's right. That's exactly right. And a lot of, and we're not really hard at pushing that part of the rule, but it does provide practitioners who do want to provide us information. I get it. There's reasons why, but I don't really get into that. I may never know, but they are providing us with information.
Yeah. Okay, is there anything else before I kind of change the chapter here?
Sure.
Okay, so the next chapter here in the rules is just, it's very simple, very basic, is the requirement to keep confidential information confidential, which for us, that is one deviation with the ABA rule because we do have Rule 56. So there's a carve out for Rule 56 for prior art that is known to be relevant that you have to disclose or do something with in some way, shape, or form, even if the client doesn't want you to. And as I understand it, if you get into that with the client and it's going like this, OED's position is if that attorney withdraws, then you're not going to pursue.
That's 100% right. Yep.
Okay. So
the other piece you could do, now this gets dicey. We're talking generally here. It may not work because you could. Is it possible to redraft the application of the claim such that you wouldn't have to disclose?
Yeah, or amend the claims by adding limitations.
That gets sticky,
like that,
right? Because then are you doing that? But withdrawal is always an option.
Right. Okay.
And you don't have to say, I've been asked the question, and that hasn't come up. It doesn't come up terribly a lot. There's a term called noisy withdrawal. I've never heard that too. So we don't get into that. We don't say it has to be a noisy withdrawal. Withdrawal's fine for the.
And by noisy withdrawal, you mean where you're kind of wink, nod,
nod. You're stamping your foot, saying, "I'm getting."
Gotta let me out of this case.
Right. I'm getting out because there's a problem here that's going on. Right.
Yeah. Okay.
To kind of alert the office, hey, you better take a look at this case a little bit further.
And so you just withdraw.
Right. And we don't get into that kind of stuff.
So that's the distinction between the rule for confidentiality that applies to patent attorneys and agents versus lawyers in general. And it's a very narrow difference. The one that applies here in the AI case applies across the board, and it is true for both rules, ABA and Rule 11.106, which is you have to maintain client information in confidence. And that can be a problem depending upon the type of AI that's being used, whether the use of the AI by the attorney or law firm is anything put in is gonna go into the training corpus or not. In which case, then your confidential information is then released, and if not, released in a publication, it's released into this AI sphere, where then a competitor may ask it a question and be prompted, receive information back from your proprietary cache of information, and it's a real concern because once that's out there, you can't get it back.
If you've looked at some of these agreements that people are checking the box, those agreements before you dump something in, whatever, ChatGPT or any of them, they're pretty open-ended, and you have no idea where it's going, what it's going to be used for. So that is a major. If that's not, what's even stronger than a red flag? I wouldn't do that at all with a client's confidences. That's just too. If you don't know, don't do it.
And that's why the communication rule becomes so important, because you're not trying to release confidence. You're maybe being very moral, but not being very ethical, because you don't know where it's going. You have to know where it's going, and once you know where it's going, which I think we all have an obligation to know, we have to get the client's sign off on that. Mm-hmm. And that's how Rule 11.105 and 11.104 work together. Mm-hmm. Or 11.106, I'm sorry, is the confidentiality rule, and 11.104 is the communication rule. So Gary, let me ask you, what would you want to know? What kind of communication, what kind of limitations are you interested in with respect to the attorneys that work for you?
Basically, what are they using and where is it going?
Mm-hmm. And were you here yesterday when Jason talked about how we can have the greatest agreement with OpenAI, and he's top IP legal officer at Plaid. He said we negotiated their deal with OpenAI, and they got a different deal than just the open click-on agreement. And he said, but now the question is what are our vendors using? Because it's the weakest link.
Right.
So have you given thought to this tool is approved, that tool is not approved, these vendors are approved, those vendors are not approved, or are you really expecting the counsel to do the due diligence before they use anything? And how far down the chain are you thinking about?
It's something we're thinking heavily of now, and whether it's, I don't want to say it's too late, but it may be a little late in the game. Talking to our CROs, talking to companies that we're working with, and saying, are you using it? Is it capitated? Is it open? What is it? And finding out from them.
Mm-hmm. And do you have any requirement that they have you put anything into your representation agreements or anything that you require them to outside counsel to sign, or would you like to see that? Or if somebody came to you and say, hey, we're going to provide you, before we're pitching you for work, here we've done our own internal audit of what our attorneys are using for AI, and this is what we're using, and this is how we've secured it. Is that what you want to see, or what level do you expect?
Yes, it's in the works.
Mm-hmm.
It is basically the answer.
Mm-hmm.
Do you want to
Okay. We have a question. Go ahead.
It's not just a matter of client consent. It's also putting it out there in public.
Right.
It's now in the public domain.
Right.
Yeah.
Right.
Right.
Exactly.
Right. Is anybody else?
You don't know. You
Right.
don't even know where it's going. I think
It may be out.
it probably, you should assume it is, right?
Right,
I
right.
think that's a good assumption. And you're disclosing confidential information, right? That
And can you imagine the cases that you're going to get once that happened?
hopefully
and
I'll
then
be retired, but no.
Well, no. Maybe. I mean, what we've learned here is things are moving at the speed of AI is a different speed. It's not quite light speed, but it's it's a fraction of light speed that this moves in, and I know the case is coming where party A and party B, company A and company B, they're competitors, and somebody at company A somewhere in their chain, internally or outside counsel or somebody used some open AI, and then that information gets put into the database, right? And then somebody at company B, who's their competitor,
Doesn't even know, right?
Doesn't
Yeah.
even know, and they prompt, and then they get that information, and then they put it into their application, and then what you wind up having is that, well, who's going to own that patent? Well, it'll be co-owned by A and B, And once companies start seeing that happen, the first decision that happens, oh my God, I don't want to be any of the lawyers on either side.
Right. And I think the point here, and a point with a seminar like this, is there are a lot of issues with this, right? There needs to be a lot of education as to what the pitfalls, the advantages and the pitfalls, what you need to watch out for. So those discussions should be, I would think, starting, or if they haven't already started or happened, in a company, in law firms. They're certainly starting in government agencies like the USPTO, where we're basically said, hey, you're not allowed to use that. Just stop, right? We're not even going to don't even go on that.
Yeah. And the one thing I just want to punctuate is if you can think of a parade of horribles that relates to the litigation that's going to be between competitors or because of the use of this in the patent context or whatever, then that means there will be ethics investigations.
Right. Lawyers are great at that, right? Because
Right.
coming up the parade of horribles that could come out of this thing.
Right, but that's where you get a lot of your issues flagged, whether it be from other opposing attorneys or unhappy clients or judges. I always tell people when I give an ethics presentation myself, my first slide is don't commit malpractice. And everybody laughs. It's
That's
like,
good advice, G.
well, why? Why is that the first thing you say in an ethics is because if you commit malpractice, the odds that you're going to get an ethics complaint go way up.
Right.
Right?
But don't be afraid of it. I mean, again, that's the point I think of this, is bring it back to basic principles. They really haven't changed. Like for you were just talking about confidentiality of information and disclosing non-public. I mean, that's not new. That's not a new concept. Communicating with your client, understanding, so everybody understands. Very basic. So don't be afraid of it. Just think through it a little bit and some of the rules that Gene I mentioned.
And then with the malpractice thing too, if you make a mistake and you don't fix it, that's a deviation in the standard, right? And then so that's like, whether it is technically an actionable malpractice that somebody could sue you on, it is a deviation in the standard, because as we talked about earlier, you expect that people, if they make mistakes, they're gonna, 1, come clean, 2, cooperate, and 3, do something remedial to make sure it never happens again, right? So if you're not doing that, then that's a deviation in the standard of practice, whether or not it's an actionable deviation or not. And those are the things you want to avoid. So you can't just bury your head in the sand like an ostrich.
Yeah, and one thing I just thought of too, and I think this would be kind of good to bring into the AI discussion, because we saw it in, if you do trademark work, a few years ago, there's something called the U.S. Counsel rule that came through in August of 2019. I can't tell you how many times we hear, gee, I didn't know about this, and now it's 2024. We're still hearing the same thing, right? So you need to make sure that you're keeping abreast of the changes, and especially in this AI area where things are changing. And I will mention the PTO to help create a web page where we're putting documents and things that sort of a one-stop shop you can go to and pull the documents we've kind of chatted about here today and we'll continue to use in the future. But I'm always amazed when we hear in these local counsel cases, these trademark cases, gee, I didn't know what the rule was, or I wasn't, which we thought, okay, back in 2020, things changed, maybe you didn't get to your CLE that year or whatever. 2021, the curve just starts to drop, right? Yeah. And now in 24, it's almost like we're just like, when the investigators they come to me and they tell me this, it's like they're really angry that the people they actually have the audacity to say something like that 5 years after the fact. Because if they don't know it 5 years after the fact, they won't know it 10 years or 15 probably.
Right.
So again, keep this is one area you got to keep up on, I think.
No, absolutely. I think that's very true, because it's changing fast, and as it changes fast, then the expectations for us as practitioners are going to be changing very fast. And what is considered best practices is changing all the time, literally. Now, the one issue that, I sent you an email, I asked you, hey, I just read this. Have you thought about this at all? Because I hadn't thought about this and I don't know that it's so much an ethical issue as much as it is one that is a derivative of an ethical issue, is as we talked about, you're not keeping these confidences is the big problem. Are you or are you not keeping the confidences of the client's proprietary information when you're using generative AI? And the answer is sometimes you will be. Sometimes it's fine, depending upon the terms and conditions. You very well may be. You also very well may not be.
Right.
And it doesn't matter whether you don't know, right? It doesn't change the fact that you've let the client's proprietary information out of the bag. The fact that you didn't know, it almost hurts you because you didn't inquire, carelessness, and that sort of
goes right back to knowing, hey, what's the current state, what's going on
Right.
in 2024.
And competence, basic competence.
Right, exactly.
And so,
talking to your client, too, about it.
And talking to your client. Okay, so but now let's assume you did something and you let it out there, and the thing I sent you about was read an article, somebody said, hey, this could kill attorney-client privilege.
Right.
And I hadn't thought about that, but maybe
I'm going to wait for the first court case, because I'm sure somebody's going to get to that case pretty soon. But
yeah, no, and it will. There will be a case on it. There
Yeah.
have to be a case on it, right? Because if you could force your attorneys who gave you advice to testify, who's not going to do that?
Right.
So there will be a case, probably in the not too distant future, that raises that as a problem. So if we haven't scared you enough to be asking questions as to where the server is and very basic due diligence, where's the server, and is it an open AI or is it a closed AI?
Right.
And if you don't know that, you may be causing other problems that you can't possibly imagine.
Right.
In our space, we already know that a lot of clients, and maybe Gary, if you have thoughts on this, you don't ever want the firm who prosecuted the application to be the firm that's litigating the patent, right? For this precise reason, you don't want to do something unwittingly to breach the attorney-client privilege. Mm-hmm. Any thoughts on that, or have we beaten that horse to death?
No. My thought is what's going on in Brazil. If they allow AI to be an inventor, what if I file something in Brazil? Do I have to get a foreign filing license? Where is
Oh my
that?
God.
Where is that server? Is
that's
it where the server
yeah.
is, or where the person was that put in the query?
We didn't talk about that at all, but
And then-
for those who aren't aware of what Gary's talking about, there was like a week ago or 10 days ago, there was one of the legislature members in Brazil filed a bill to allow AI to be an inventor. And I haven't heard from my contacts in Brazil whether, is this grandstanding, is it just for headlines, or is this got
They wanna be
actually
the
got
first, right?
a
Yeah.
chance, right? But they could very well want to be first.
Right.
They could. It would make a lot of sense for a country to do that, right? Among other things, you would immediately get people applying that couldn't get protection anywhere else. And if you get people applying, then you're bringing potentially companies and jobs there. Mm-hmm. But I didn't think about that. Foreign filing license. My God. This is a full employment act for you guys at OED. All right, so we have 3 more minutes that we have to kill. Does anybody have a question? And if not, we can talk about some other stuff going on at OED to make sure we all get an hour.
Here's your chance. Anything you want to ask?
Okay, so, go ahead.
Okay, go ahead.
You mentioned you sometimes get, neatly written up referrals for things you should look into.
Right.
What percentage of things do you actually take on, and how do you kind of?
At 100%. We look at 100% of what comes in. Now, do we open formal invest? It's very possible. I don't know your names. They can't see your
Dan.
Dan, right? Look,
No, his
your
name is Tom.
number
This is Tom.
37123, right?
Asking for a friend.
So it could be. It's possible. We do look at 100% of what comes in. We decide within, because we have that 1-year statute of limitations, we look at within 30, 45 days, we do a quick look at it. Is there something here? Is this something we would want? Is there potential here for this case? And if we decide no, there's not, and let's say somebody sent a letter in about you with all the tabs and indexes, and they said Dan did blah blah blah, and then we didn't do anything. You would never know. because we would never contact you. But if it makes it past that first gate, which about probably half of the cases do, then it's like, okay, we need to ask some questions from the practitioner. Because we realize, one, after today, you never want to see me again, I'm sure, right? You never want to hear from me, or you don't want to get a letter from me or anything, right?
I told you that. There's been times, and we're friends. And
You're hard stuff when I call you.
My staff will say, Will Covey called, he needs you to call him back. And for a minute, my heart stops.
Well, when you guys send out these surveys,
well, they're gone, but yes, they're gone, but we used to, the blue piece of paper, right?
Yeah.
The blue piece. Yeah, no, that's just to check your address, make sure your contact information. So half the cases we never even tell you, because when I started, we used to not do that. I realized when you get a letter, and we are trying to get the facts, in let's say 100, 150 of those cases, see what happened, get your side of the story. It probably doesn't feel that way, and I tell the attorneys, hey, you need to make sure we're trying to maintain an open mind as to what didn't happen. Out of that 100, 150. In any given year, we have about 30 to 40 actual published decisions. So the rest of them, they go with non-public. Either just the attorney explained it to us, and we said, hey, that's fine, that's good. Or they get non-public, some type of what's called a warning letter, and basically a reminder. Things like what Gene mentioned, taking corrective action, fixing things, kind of working with us to kind of figure out how does this not happen again in the future. That's fantastic. But we do, the opposite side of the spectrum is people who refuse to respond to us, think it's going to go away.
Mistake.
Big mistake, and it's never going away. And then, then we'll go very fast track we'll file a complaint, and then they'll get then they won't respond, and then they'll get the default judgment. And then it's just never good things come out of it.
Yeah, no, in the cases where I've represented people, and I haven't done it for a few years now, but I remember the reaction from OED. It's like you've now gotten over the threshold, and now you're going to make an inquiry so you can get the practitioner side. And at times, people who don't really think they've done anything and are afraid, they've reached out to me, and then I've worked with them. And I remember OED, one of the folks who worked for you said, we almost never have representation at this stage. All we're trying to do is find the facts. And I said, I get it. They're scared to death because they don't think they did anything wrong. I don't think they've done anything wrong, but we're happy to work with you to help you reach that conclusion, answer any questions you have, and we'll tell you what really happened here. And that response goes an extremely long way. The people who avoid or lie, that rule's stupid, it's unconstitutional. It's like, look, when you're in a ditch, put the shovel down. Mm-hmm. You have to cooperate. You must cooperate. So,
any other questions?
I'm
happy to answer anything.
All right. Well, we have safely gone 2 minutes beyond the hour, so everybody has got a full hour of ethics credit. Thank you, Will, once again. Gary, thank you for joining us for this. And the conference is now adjourned. We hope you will join us for lunch. Thank you for coming, everyone.
Thanks. All right. It was good. Good to meet you, Gary.